Good morning, sir. Are you Moses Jones, Jr.?
Yes, ma'am. Good morning, Your Honor.
Good morning. And Mr. Parker, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Jones, in cause number 25 DCCR 0848, the state has elected to proceed. Can you hear me? You're having a hard time? Is that better? Is it better now?
Yes, ma'am.
All right. So in cause number 25 DCCR 0848, the state has elected to proceed on the lesser offense of a Class A misdemeanor assault family violence from June 15th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with in that lesser offense?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
And do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection?
It's admitted. Is any evidence that Mr. Moses is not competent?
No, Your Honor.
All right, Mr. Moses, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor, assault family violence. Sentence you in accordance with your agreement to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody.
3 months.
You'll get all that credit. You'll get all the credit that the law gives you the right to receive. And I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. There are some rules with regard to that because it is a family violence assault, even though it's a misdemeanor. So if you have any questions about that, you can talk with Mr. Parker. Read that document I gave you. It will also explain to you all of the factors that go into your ineligibility to possess a firearm or ammunition. Because if you do possess one and you're not supposed to, then it could lead to further charges. Do you understand? All right, good luck to you, sir. You can go back with the bailiff. Ms. Thomas, I have a motion to revoke your unadjudicated probation. And it shows that you were placed on probation April 25th of 2016 for the offense of forgery, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department August 20th, August 28th, September 13th, and October 10th of 2018. Is that true or not true?
It's true.
And then count 2 alleges that you failed to provide verification of performing the community service hours as directed. And is that true or not true?
True.
And then count 3 alleges that you are behind in your court assessed fees. And is that true or not true?
It's true.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
I did.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 5 years in prison. So it means as long as I give you 5 years or less, if I revoke your probation, then you can't appeal that decision. Do you understand? State tenders number 1.
No objection.
It's admitted. Is there any evidence Ms. Thomas is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm going to reset your case so that the probation department can do an updated report. That'll give me more information about what's been going on, your probation, and then we'll come back at a later date for sentencing. Anything that you think is important for me to know, get that information to Mr. Parker, and he will present it to me on your behalf when we come back. All right, you can go back with the bailiff.
Thank you, Judge. Oh, Judge.
Yes.
She's on deferred and does not have a bond. I told her I would request a bond. She has the ability to get back to work. She's been working and.
I'm up in LA right now, so I'm just trying to get back to work. I work at a nursing home.
Well, you've been gone for 7 years. And so I don't know what's been going on for those 7 years, since you've been on deferred probation, starting in 2016. It looks like you stopped reporting in 2018.
Yes, ma'am.
Based on that, and based on the fact that I have no other evidence at this time, I am going to find that it is in the best interest of society and our community at this time, that I not set a bond in your case. Let's get the updated pre-sentence report. I want the probation department to be able to look into what's been going on, and then we'll see what happens at the next court date.
Thank you, Judge.
Go back with the bailiff. Oh, I see. But the, I don't see the, registration. I don't see it there either. Hold on, let me double check. There it is. Okay. Okay. All right. You're Andrew Jackson?
Yes, ma'am.
And Mr. Jackson was previously in court, entered a plea of guilty in cause number 23 DCCR 0045. Hold on a second. Which was the offense of sexual assault of a child. The agreement was for 12 years. I did not order a pre-sentence report. Is there any reason not to go forward with sentencing at this time?
Nothing, Defense.
All right, then, Mr. Jackson, in cause number 23, DCCR 0045, find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time, find you guilty of sexual assault of a child. Sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Also, you signed today, and I do want to make sure you understand that as a result of this plea, you will be required to register as a sex offender. You understand that as well?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank. It's my understanding that there is a victim impact statement. If y'all will have a seat at council table. All right, thank you, Mr. Coleman. All right, ma'am, again, you're Rebecca Rideau. And Mr. Kimler, will your client waive the formal reading of the indictment?
All right.
Let's see, Ms. Rideau, in cause number 25 DCCR 0336, the state selected to proceed on count 1 only. It alleges you committed the third-degree felony offense of tampering or fabricating with physical evidence, and that's from October 2nd of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow this agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Rideau is not competent?
None that I'm aware of, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of tampering or fabricating with physical evidence. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. This will run concurrently with all of your other felonies, which is specifically cause numbers 23 DCCR 0928, 23 DCCR 2106, 2107, and 24 DCCR 1925. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. Good luck to you, ma'am. You can go back with the bailiff.
Thank you.
All right, ma'am, again, you're Gabrielle Smith?
Yes, ma'am.
Gabrielle Smith, I'm sorry. And Mr. Kimler, Ms. Malfino?
Well, I was looking straight in here.
Judge, we had previously been before the court on a PSI, and the court understandably, based on that PSI, rejected the 5-year cap. I then made an offer of 8 years, where I still am today. Mr. Kimler wanted to argue, and obviously that's his right to do before the court for maybe a little bit less time than that, but I didn't feel comfortable making any other offer myself without the court's input or permission. Obviously, her original PSI, her criminal history
Do y'all have
is
that?
horrendous. Now, the
Original
facts
PSI?
of this offense on their own obviously are not super egregious, but the history is, and so that's kind of what we were.
I guess, I mean, if y'all, if y'all want to do a cap of 8 instead of the 8, I would take a look at that, and then we could talk about that, and then I would, obviously it's something that the cap is what it is, and then I've got the PSI. I don't know that I would need an update, but if you needed time to put something together, then we could reset it for sentencing if y'all wanted to enter that plea today.
Obviously, I don't have the priors in front of me. I requested them from Louisiana. I
Okay.
don't want to represent 100% that I believe Ms. Smith is habitual. I do feel very confident that there is more than enough to get me there, and proceeding in trial, that would be what I would like to do. Again, the underlying facts of this offense, standing alone, don't appear super egregious, but in combination with the history, I would feel better with a cap and allowing Ms. Smith to make argument on her behalf. I
Sure.
certainly won't stand in the way of that.
Okay, all right, if y'all want to visit about that, do you want to visit today about that, Mr. Kimler? Do you want me to, I can reset it a week or so if you'd like some time. Sure, okay,
Thank you, Judge.
okay,
NTR.
perfect. Sir, you're Leonard Guillory, and Mr. Guillory, Mr. Lewis has let me know that your family has the intention of trying to hire an attorney, is that correct? So what I'm going to do is reset your case, a normal reset, that's about 30 days. Mr. Lewis is still on your case, unless they hire someone between now and then they'll file the appropriate paperwork to get on your case. If for some reason they're unable to, then when we come back, you'll need to discuss your cases with Mr. Lewis, and then we'll go forward that way, okay?
It was I just wanted to point out, I did talk with Mr. Guillory. He did have an issue about his, of course, his bond. I told him that I could file that necessary paperwork, and then of course if Mr. Kimler wants to adopt it, he can. But
Sure.
it'll already be in process.
All right, and so if Mr. Lewis or Mr. Kimler or whoever else files a motion asking me to reduce bonds or anything like that, then we'll set it for a hearing very quickly, and I'll hear that at that time. Okay, you can go back with the bailiff.
All right,
Thank you, Mr. Lewis. Mr. Matuska, did I see on Michael Brasher? And Mr. Brasher, in cause number 23 DCCR 0944, you're charged with aggravated assault against a public servant. And your bond conditions include having a scram device. Give me just a second to get all this pulled up, please. And I received an email from the alcohol monitoring company, Recovery Monitoring Solutions, on August 26th, that you had been non-compliant for not taking care of the maintenance or uploading your data from your scram bracelet. And
For payment, Your Honor. To be exact.
well, for not taking care of the maintenance and for not uploading your data is what they said. And so if you're also not paying, then that's another thing that you're not doing correctly. But the fact that you're out on bond, that you made $150,000 bond, and part of that bond that, so that I was comfortable, was for you to have that scram bracelet and for it to be working at all times.
Yes, ma'am.
So since then, I set it for hearing for a bond review compliance, and Mr. Coleman has filed a motion asking that I increase your bond because of that non-compliance. Are you working?
I just got a job in the oil field, Your Honor, and my first check was just really 2.5 weeks ago, and I've been trying to get caught up on everything. Most importantly, I was trying to get caught up on my bond payments, and I still have that monitor on too. I am caught up on theirs. I was about to go and pay for them until I got the call and I got deactivated. So I have no failed alcohol or no failed readings. I'm also on probation.
But I don't know
County.
if you have failed readings because you weren't uploading.
They were getting the data, Your Honor. They got the last data as soon as I got there too. The Corpus Christi office did. And I'm also on probation, Your Honor. I have to have a portable breathalyzer that I also have to test for them 3 times a day. I mean, both, you know.
So you're on probation where?
In San Patricio County.
Okay. And you have a portable breathalyzer there?
Yes, ma'am. I'm supposed to have one for the vehicle, that one, and I mean, I'm supposed to have this one too. But
Okay. All right. So,
I asked for paperwork.
do you have any kind of proof of the San Patricio County conditions of that probation?
No, Your Honor, I do not.
All right. So let's do this. I mean, obviously I want you doing what you're supposed to be doing on bond, but I also don't believe that it's necessary or financially probably to have a scram, a portable, an auto ignition, and a GPS. That sounds like a lot. So what I'm going to do, I need you to get immediately to Mr. Matuska some documentation from your probation office in San Patricio County that you have that portable device. And what I'm going to do is order that instead of the scram, I'm going to remove that order, that condition order of your bond. And I'm going to order that you all have the portable device here also. That doesn't mean you have to have 2, but I need that company to know that they need to also send us those results. And so, Mr. Matuska, if you can help coordinate that, we'll get that bond condition done. But I think I need that company's information so that our clerks can send that is now a bond condition to them, and they can keep us updated just like they're keeping San Patricio Valley, or this county. Does that make sense to you also, Mr. Coleman?
Yes, Judge.
Okay, so I'm not going to raise your bond today. I'm going to remove the scram, but order that you continue that portable device. I just need those results as well, okay? Make sure you make that a priority to get that information, work with Mr. Matuska. If I'm not getting those results, then we're gonna be right back here and I'll have no choice but to raise that bond. Okay, all right, you can go.
Excuse me, this was a re-indictment from 23 DCCR 1034. I will dismiss that if I have not already.
It's
Went
not
from
showing
a-
up on the docket, so I think it might have already been done,
Okay.
but we'll check.
Just wanted to let you know, we went from just a robbery to an assault public servant. I think that tracks the
Okay.
facts better.
Thank you, ma'am. And will your client waive the formal reading of the indictment?
So wait.
Ms. Smith, in cause number 25, DCCR 0979, you're charged with a second-degree felony offense of assault on a peace officer, and that's from June 10th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal.
Yes, ma'am.
And the agreement is for a cap of 8 years in prison, which means you're leaving your sentence up to me. And as long as I give you either 8 years or less, you're waiving that right to appeal. You understand? You have an absolute right to have a jury come in and decide 2 things. The first would be to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to that jury. Do you understand?
Yes.
And if we go forward this way, you're waiving that right. And is that what you want to do? Also, do you understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number
No
one.
objection.
It's admitted. Any evidence Ms. Smith is not competent?
No, no.
All right, Ms. Smith, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm just going to reset the case maybe 2 or 3 weeks. We've already got the pre-sentence report, and so that'll give y'all time to get any other information together that you need, and we'll come back for sentencing in about 3 weeks, okay? You can go back with the bailiff.
Thank you.